Hi, everyone. Welcome back to Title IX Insider. Today, we have a very special organization joining us to discuss some very important topics, especially in regards to respondent rights and due process. And again, as usual, please make sure that you like us, subscribe to us, especially today, because of the fact that we do want to hear comments and we want to hear what you all are thinking, especially as we're having this deep conversation today. And so to begin, I'm going to say welcome first to Samantha Harris, also to Aurora Knight and Eric Rosenberg, all from FACE, Families Advocating for Campus Equality. And Eric, you're going to go ahead and get us going by just letting everyone know what FACE is and what you all do.
Sure. So FACE is an organization that was started many years ago by the mothers, a group of mothers of young men who'd been falsely accused of sexual misconduct. And one of those actually was my client. I'm a lawyer. And at the time, I recall, this client's mother, who do I talk to? Who could possibly understand or relate to what I'm going through? This was in 2011, 12, in that time frame. And what happened was a couple of mothers got together and started talking about their shared experiences, and that grew into FACE. FACE is now an organization that has helped really thousands of families across the country who are involved in disciplinary proceedings, as particularly Title IX disciplinary proceedings. We have a lot of resources and networking tools available to help families that are processing, usually respondents in Title IX cases.
Thank you so much. And today, we're here to discuss exactly what FACE does, what some of those stories have been, and really, do a little bit of a deep dive. But I do want to state to our audience that we are not picking sides. We want to ensure everyone understands that due process is due process for everyone. And it is important to discuss and describe what exactly goes through the cases that respondents are part of as well. And so, Sam, I'm going to pivot over to you because I'm curious what your thoughts are and what your work has been with FACE.
So I am also, like Eric, an attorney who represents a lot of students in campus disciplinary proceedings, primarily respondents, but I have also handled some cases for complainants. And so I think you made a very important point, which is that due process protects the integrity of the whole process. And so regardless of whether you are a complainant or a respondent, you want it to be a fair and thorough process. Not one where all the evidence isn't considered or the decision maker is biased. But unfortunately, that is something that, particularly back in 2011, but to this day continues to be an issue. And one thing, I became involved with FACE as a board member, and FACE does something really important that no one else outside of a respondent's family can really do, which is provide a support network for people who are going through this. I mean, one thing that I know Eric and I have both seen is when you work with these clients and their families, it is extraordinarily isolating. Being accused of any type of serious misconduct, but particularly sexual misconduct, is extremely isolating. It carries a lot of stigma, and in a lot of these campus cases, we're talking about very young people. This may be one of their first experiences altogether. So they're new to college, they're new to being on their own, and suddenly they are grappling with this. And so, one thing that FACE can do is kind of help people connect with maybe an advisor or attorney to help them in that process. But I think one of their most important roles is really just providing support. We have online discussion groups and meetups where people who are going through this can share their experiences and can just feel less alone. And the mental health component of this is huge. And I think that's a place where FACE is doing really important work.
I love that you just mentioned that. I think that's one of the biggest areas that we, for Title IX Consulting Group, through this podcast, I've really been trying to find those areas and those nuanced organizations that really focus on that mental health support. Obviously, we all see everything for the survivors, those that are accusing, right? There is a lot of support out there. But when we look at the support for those that have been accused, those respondents, it is minimal. Can any one of you describe or help us to know a little bit more about that branch of it? What do you provide? What is provided by FACE for those individuals? Do you have mental health services or like you described, that support group? Is that support group offered weekly, or what kind of information can you share?
So we don't have, counselors on staff at FACE, but we have intake teams, which include mothers of falsely accused students over the years who can help direct that. But it is really critical to get that help early. Sam, I'm sure has taken them. I've taken suicidal calls from accused students over the years. I'm representing right now a young man who killed himself because of a false allegation of sexual assault. So these are very serious allegations, and to be proactive about that. So I think so FACE does help plug families in early, so that they can avoid a lot of the pitfalls that fall. Unfortunately, many people, when they're first confronted with an allegation, think that the truth was going to set them free. I'll just tell the truth. It'll be fine. I'll be out of here by the afternoon. And that is not the situation oftentimes in the Title IX world. So you have to be very careful that you get early quality help on how to proceed.
We do not, no one on FACE's staff is a licensed mental health professional or anything like that. So nothing that FACE does is a substitute for actual therapy or counseling. But I think combating that isolation and giving a people a place like these groups, these online forums where they can connect with one another and share experiences and perhaps share those types of resources with one another, and help connect one another with those types of resources is something that FACE does.
I see. Okay. So it's a support group where individuals that have been accused can come together and chit chat and
And
share
their families, and their families. Yeah.
and their families. Got it. And so I guess when we talk about families, Aurora, you're on here today, I am assuming because you are part of this family group that has been there for supporting respondents. Is that right?
Yes, I was fortunate enough to get connected with Faith in a moment that was absolutely a disaster. And I'm sorry, just because I connect with a lot of family of faith, and they were my backbone. Because I had no idea where to go, what to do, what was going on, and why my son was involved in a Title IX investigation. I don't know if you know about Marcus's story or not, but
No.
Marcus got this Title IX accusation for fist bumping. There was no hugging, no kissing, no sex, no inappropriate touching. It was fist bumping. And so find myself a family in a situation where there were family were very heavy situation, and I was there with a fist bump, and they offered me the great support and guidance to help me to, we went public, and, of course, with my son's consent, because the absurdity of having a Title IX, a sexual harassment case on a special need. Also, my son has autism and cerebral palsy for fist bumping. And without FACE, I don't know. I had no idea where to go. I have seriously no connection, because I spent all my life to be sure that my son was seen as a valuable member of society. His academic always being to the point, absolutely fantastic, excel in a lot of things. Of course, he has autism, there is nothing we can do about that, right? He has cerebral palsy, and he worked with that. He did everything to show that he was capable to do what everybody else was doing. And the fact that fist bumping get him in this nightmare that is now 8 years long, 8 years of his life and my life, it's absurd.
I'm so sorry. I'm so sorry that happened. I know I've seen that as an expert witness on cases, the unfortunate absurdity of the extreme side of Title IX where cases like that take place. And I'm sorry that you experienced that with your family. I'm sure Eric and Sam, you guys can both speak to cases like that where unfortunately administrations don't truly understand Title IX as deeply as they should. And all of a sudden something is stamped with that Title IX process, and then lives are disastrously affected. Do you want to speak a little bit to that as far as the administrations and
Yeah,
what
I
perhaps
mean,
could be a problem out there?
I think Sam, but yeah, I've represented and we've done, many, many autistic children. And what you normally do is there is a lack of understanding, even academia, about about autism. So more often than not, when we have cases like that, we reach out to an expert to kind of help explain, this student has autism. They need to have these kinds of certain protections in place. One of the challenges from a legal perspective become, do they have an IEP before you get there? But sometimes the Title IX office will push back and say, well, you only get whatever it is we're going to give you in the academic world. And then you have to really explain why this is totally different. Because in the disciplinary proceeding, particularly in many Title IX proceedings where the students have to do most of the things by themselves, they can't have the lawyers help them. Students who are autistic can have a very difficult time reading and understanding the room, things like that. So you have to try to get certain things in place, which can be very challenging. So you have to look at when you have a student with a disability, whether it's on the spectrum, ADHD, something, you have to try to make the adjudicators understand this is the student's limitations and how are we going to address that student's, because the stress of that situation is far greater than taking a test. If the student's been accused of sexual assault, the stress level is much higher. So it is an important issue to look at, and I'm sure Samantha has some other points to add on that.
Yeah, I mean, the other thing I was going to say about students on the spectrum is that, you see a fair number of these cases because, a lot of cases involving students on the spectrum involve not any type of sexual or sexualized intent whatsoever, but a simple failure to understand social cues. We have cases where somebody simply stands too close or asks for a date too many times or things like that, not because they're trying to do anything wrong, but because they're simply struggling to understand the social cues. And I think there's a little bit of a disconnect between schools, desire to try and integrate students on the spectrum into the broader student population, and then this kind of lack of understanding and compassion they display when they may have social struggles. But I think, even beyond the cases that are sort of what you might call outliers in terms of the level of physical contact, like a fist bump or what have you, there is a kind of black and white way in which a lot of university administrators view Title IX that I think is unhelpful, because it misses a lot of the nuance of, students who are kind of figuring out relationships for the first time. And it deals, I especially, and I don't know, Eric, if you do any criminal work, I do not do any criminal defense work. So the cases that I get, the respondents that I represent, because if somebody comes to me and it's clear there's sort of potential criminal involvement or there's a police investigation going on, I will always direct that person to a criminal defense attorney. So the cases that I'm working on are cases that are not suitable for prosecution, right? They are misunderstandings and miscommunications, usually around what we call an affirmative consent standard. And we can talk about that if you want to get into it later, sort of a different consent standard that's used on campus versus in the law. But misunderstandings where people have a miscommunication and then the respondent is unable to demonstrate through producing evidence that they had clear, and unmistakable consent. And so there's a lot of situations, even situations that do involve real sexual activity, where you have people who are absolutely bewildered by how they have ended up in a situation like this and did not have any ill intent and are left completely uncertain of how to proceed in these situations.
Right, right. And I think for me, with Title IX Consulting Group, we now are doing trainings, and we are very focused on that due process and the being trauma informed, not only for the complainants, but also for the respondent. How do you, as an administrator, ensure you're being trauma informed to not cause that trauma towards the respondent themselves, whether they're on the spectrum or just someone that, you know, really did do something and that needs to be criminally investigated, as you just described. The administrations still need to be aware of how they're behaving and ensure that they're giving those rights to everyone equally. And that's where we're kind of missing the boat right now. I think a lot of times administrations are being taught to just check off the boxes, and that human aspect is completely being thrown out the window. And that's where we're seeing a lot of the harm coming into play. And I wanted just to quickly address the fact that we discuss friendly warnings very closely, which is something that is very new, because I think some of the bigger organizations, when they do their trainings, it's, as you guys just described, black or white. It's there's no in between. There is no prior conversation. Hey, was there a social cue missed? Hey, maybe don't do A, B, and C. And what if we were to look at different approaches and really look at that informal resolution a little more seriously, because something was a misunderstanding. And so there's that kind of missed opportunity many times administrations are not looking at. And then also the fact that disability offices, just mentioning the disability portion, disability offices are not connecting with the Title IX offices directly. And so then we're having a lot of miscommunication and things, again, just dropped and missed. Any thoughts on that?
If I may, we did have a lot of conversation when we start with this process. That at first we were called with a meeting, and I made clear, and I said, look, my son, to make friend, and actually that was to avoid any touching, right? Because I always leave with that fear that something can happen to my son. So I told him, don't high five people, just fist bump. So there is not contact, right? So fist bump is easier than, is actually better. Don't tap on the shoulder, so we just a fist bump. And I explained that. I mean, that what is difficult to have an individual and they say, that's his way to make friends. And I was told that they were not dealing with special people, they were dealing only with normal people.
Hmm.
So that was how it was explained to me. And Marcus was picked up from the campus police and from the cafeteria. And he was terrified. They didn't call me.
Mm.
And so it's the decision I had, to me, in my perspective, my personal opinion, that it was only to find a reason to remove him. They didn't want him there. He was not fitting the standard of, even though my son made the dean list academically.
Mm.
So, and that's, of course, the administration never appreciated. Academic loved him because
Right.
he's a very hard worker. But going back to what FACE mean to us, to me and to Marcus, we find a family. Because like often happen, and I don't know to other family, but the one that I talked to, it happened to them too. When you have your son or, your family member accused of something like that, you become a drop of oil in water. That become all, everybody take the distance, right? Because you're special, you may be something wrong with you. And having, of course, we have, so family support, but most of the people take the distance. but family was the one that there was the tight family around us. And without their support, I will never had the courage to sit with my son and say, we need to do that if you agree. And we were public, we're going to do that, we're going to fight it.
I'm so sorry about that again. I know it's what Eric and Sam and I are all saying. It's unfortunately administrations do look at things very black and white, and that's where the compliance issue comes into play.
You brought up the informal resolution piece, and I think you called it friendly warnings, and it's a really, FACE was very involved on the first Trump administration, lobbying the Department of Education as well as representatives. I mean, we were there many times with many moms and dads, and to get informal resolution, because prior to the DeVos rules, I'll call them, because they came on under DeVos, you could not do informal resolution. They were prohibiting it, so there was no off ramp that allowed. So once there was allegation gone, you had to go to the end, and that was it. So that was a very important part of the DeVos regulations, in addition to the due process protections, was that off ramp. Because and I've been sad to see in the last few years, and I'd be curious, if Sam were to chime in. Now, we still resolve a lot of our cases in informal resolution, particularly when they're dueling charges, because that's what often can happen in some of these long-term dating cases, that you end up having the complainant be a respondent and vice versa. And in those situations, we have a high rate of informal resolution. And even in some cases without that, we do. But I've seen, some states like Maryland have a prohibition against any kind of informal resolution if there's a sexual assault allegation. Some schools have moved to limit and try to stand in the way of informal resolution. And I think that's really tragic, because the vast majority of these cases, we've done hundreds and hundreds of these cases over the years, and I can count on one hand the amount of cases that would even remotely qualify to some sort of a sexual assault, like a real, what you might consider like a rape. Like, the vast majority of our cases are cases of dating couples, breakups, they're one nights. I mean, it's not, so giving these students an opportunity to have an off ramp is critical. And FACE moms and families were just really instrumental in getting that provision passed.
I think that's such a valuable point that you just mentioned right now, Eric, is that I think most people out there do not recognize or realize that when we are saying that there's a sexual assault Title IX case, they're usually really not a sexual assault case. It is, just like Aurora just described, a fist bump. It is maybe someone just kind of brushed on the arm, and that physical contact is being called a sexual assault without penetration. And so that is what's going on. Go ahead, Sam.
Yeah, I was going to say alternatively, because this is, listen, a lot of the cases that I deal with do involve people having sex. But, what Eric talks about, these dating cases are huge. So I'll give you a sort of a classic example in general terms of a case that, we thankfully were able to resolve through informal resolution. But, it was a long-term couple, broke up, college couple. And for whatever reason, there was ill will there. And the ex-girlfriend filed a complaint and alleged that, at some point in the course of their 2-year relationship, they had gone camping and she had had, alcohol and marijuana, and then they had had sex. And so that sex wasn't consensual. Now, they had plenty of consensual sex after that and before that, right? But after they broke up, she said, look, there was a time during our relationship when we had sex and I was too drunk to consent, essentially. And, under affirmative consent standards, under college policies, that may sound ridiculous, but that student who gets accused of that has to be very, very concerned, right? Because it's years after the fact. How could you possibly prove that you had consent, that the person was sufficiently and a lot of schools use a different standard from incapacitation, right? Where any real amount of drug or alcohol use can be said to negate consent. But obviously, what that person wanted was just never to have to see my client again. So we were able, and it's, listen, it's not a great resolution in my mind because, I didn't think my client did anything wrong. But at this point, they had such tight knit, they were part of the same tight knit friend group. all of his friends had rejected him anyway based on this accusation. He didn't want to go back to this university. So, essentially, the informal resolution was he goes to another university, nothing on his record. And, the risks of now typically, if someone wants to stay in school where they are, I don't recommend, let's do an informal resolution where you withdraw from school unless the allegations are very, very serious. And I think it's very, very likely to result in a finding of responsibility. But there are a decent number of these situations, especially after a breakup, when people have taken sides where the student wants to go somewhere else anyway. And a lot of times, what the other person wants is just not to have to see this person again. So, in some of these cases, informal resolution, I mean, I would say, yes, since that came on the scene in 2020, it has been a lifesaver for so many clients. And look, and it's something that satisfies both sides, right? In a lot of these breakup cases or cases where, you also have a lot of cases where, and it's unfortunate, right? Students use alcohol. They don't know how alcohol is going to affect their bodies. They get into a situation where they wake up the next morning without a clear memory, but they may not have appeared intoxicated to the other person. So you have situations where no one was intending to have non-consensual sex, but where one person is feeling terrible because they don't remember what happened. The other person is horrified and shocked to be accused because, they maybe were drinking some too. The person wasn't incapacitated or passed out. They were both just, seemed tipsy. And, when you can do an informal resolution there, a lot of times it's the best thing for both parties and no one's life needs to be ruined. So.
Yeah.
Right. Thank you. Yeah, thank you for saying that because that is true. And I do want to, for those out there listening that are survivors that have been victims of rape, these are not those types of cases. We are not describing those types of cases right now. We are definitely talking about the cases where, unfortunately, administrators are placing them into the sexual assault category as egregious, and they're not. And so they are much more nuanced, and that's why informal resolution really is a good option for those types of cases so that things can be resolved in a much better light regarding the details of the case itself. And so,
Right. And I think I want to, I think I can safely speak for all of us on this call when I say that I believe that if someone rapes someone, they deserve to be extremely harshly punished, including by the criminal justice system.
yes,
I also believe that even they are entitled to due process,
yeah,
right?
yeah,
But, we are talking about, and these are not outlier cases for us because of the way schools define consent, and the very different standards from the law. There's a lot of things that fall under the umbrella of Title IX that are not your sort of conventional sexual assault or rape case. And so I want to just be clear that, no one here thinks people should be getting away with sexual assault.
Yeah,
correct.
now if I may, I heard so many cases, and now explain to me how come my son has 2 Title IX on his record. They did not remove it. He cannot go anywhere. He cannot finish his college. He cannot do anything. His life is completely ruined. And if you already come with a disadvantage for your, his disability, his condition, and you work so hard to overcome that, to prove himself, now he's being depraved because they refused to remove this Title IX off his record. And during one of, they offered the support, the emotional support and everything at the college, which we did take advantage of. And during one of this meeting, it was explained to me that it's not Marcus' action that was wrong, but they cannot control the way that was received. That the person that received the fist bump may receive something different. And while they were saying that to me, that psychologist that was in the meeting grabbed both my hand and squeezed it. And I told her, I said, I'm sorry, what are you doing? I said, I want to show you my compassion. And I said, well, how was I supposed to say that to understand? I did not receive it that way. So should I file now sexual harassment against you because you grabbed my hand and squeezed it? If my son fist bump is misunderstood, how can I understand you grabbing and squeezing? So that is not the same way to look at things. And the Title IX, I understand everything that happened. I understand, and unfortunately, our sons had to have a check mark list when they go with in a relationship, guys or girls. So, they had to have a checklist and sign consent. But I still, after 8 years, I don't understand why my son is in it.
Yeah,
Right.
Aurora raises a really significant point that so many FACE families wrestle with. And thank you for sharing that, because I mean, what people don't understand is if you're found responsible for a sexual assault or a Title IX, you're academically and professionally, your life can be over. And you can't, so, we file more than 20 lawsuits across the country. We don't do that unless they have no other option. So we have cases where my client wanted to go to law school, couldn't get into law school. We filed a lawsuit. We got his record expunged, and then he went to law school. So these are very important. The other thing I just want to quickly hit on here, what Aurora mentioned, is the university provided support staff. Now, a lot of schools will offer an accused student university provided support staff. I don't know, I hear Sam's position on this, but I routinely tell students, I think most people at FACE say, don't use those universities because they are not always safe places to go. Sometimes you're talking to someone who's a mandatory reporter. We've had cases where a student will talk to somebody thinking it's a confidential source, and that person will go to Title IX and report them, and then they'll end up be charged with something even though they thought they were going to somebody for protection. Or they'll get really bad advice from someone who'll say, well, you should just, you did it, she's a victim, you should confess. And then they do what they think is the proper thing by an authority figure at the school, and before you know it, they're done. So anybody watching this podcast, if you're watching this before the accused student talks to anybody, the most important thing you can do is contact someone like FACE and contact a qualified provider to help you understand how to interact with the university, what to say, what not to say, when to say it, because the truth will not set you free in most of these proceedings. I often tell my clients, there's lots of ways to tell the truth. You should tell the truth, but you need to tell the truth in a way that is, conducive to where you need to go.
Right. I mean, the saddest thing that we see, and I'm sorry. Oh, you finished.
No, go ahead, Sam. Go ahead. I'm done.
I'll just say this real quick, and then you can jump back in. The saddest piece of this, the advice that we have to give people, is so often, someone will text somebody and say, gosh, when I woke up this morning, I was really hungover, and I really feel like you took advantage of me last night. And the person will write back and say, oh my gosh, I'm so sorry. I had no idea. I never meant to feel it. Boom, exhibit A. So, in addition to communicating with the administration, what people need advice even on how to communicate. It's horrible that you got to tell somebody don't apologize, but the number of apologies that I've seen, and I'm sure Eric has seen, used to find students responsible as some type of admission of, look, you said you were sorry. Why'd you say you were sorry if you didn't think you'd done anything wrong? And it's like, well, because I'm a basic, decent human being. And if somebody tells me I made them feel bad, I want to tell them I'm sorry. And I'm not admitting to some sort of policy violation. But I just wanted to make sure that if we were sort of getting into any type of preliminary guidance giving, I wanted to say that too, because it just is so important, unfortunately.
So
there is, I mean,
scouring through the website of FACE, I loved that there is that one page of information of what not to do. And it really did strike me that when it's placed, do not trust the administration, do not trust the administrators, don't use their supportive measures. As I read that, I thought, that's actually really good advice, because I have seen it where the perspectives and unfortunately the biases do come out. And that's where you just don't want to risk that. There are really good administrators out there, but unfortunately, there's also administrators that are not trained to be trauma informed and will be biased, unfortunately. And that's what
our approach, that was before I got with FACE, because I honestly tried to do everything to resolve that situation right away. Because my son got very, stressed about it, and his takeout from that he was not allowed to make friends, and he was not allowed to be in public with others. so then after that point, I, searched for additional help. I was told from other family that the same procedures that they did with my son was done to others to eliminate them from campus. And what I was told, they said they're doing the wrong thing to the right person because you're not going to be quiet about it. And I will defend my son till death. I mean, they have to just kill me for me to stop. And it's to me unfair that our sons need to go through that. In Marcus's case, it's crazy that he ended up having 2 Title IX, no one, 2, in his record, and they refuse to remove it.
Yeah,
They refuse to remove it.
I mean, I've seen it in cases, and unfortunately it is that campus culture when they really do want to go against the respondents, that it will be multiple cases. It'll be, that is why, as Eric mentioned earlier, that is why unfortunately the only resolution is to do a lawsuit at that point against a campus in order to get some change, some semblance of
We did.
accountability.
So we did, and we did one, and then the college appeal, and they say that Marcus have enough due process, and the Marcus damage was not enough, pretty much. So the sanction's still there, nothing happened, and we just wasted so many years, and nothing happened to his life. And I even received a letter that said that he was going to be admitted in campus if he's with an attendant, but he cannot sit next to a female. God forbid, and he was fist bumping somebody. That can be contagious. But based on what was studying, which is musical theater, choir, and that will interacting with people, he couldn't do anything. So.
Thank you for sharing that, Aurora. Eric and Sam, I'm kind of curious, what is on the agenda of FACE at this point with legislation? As board of directors, I'm curious if there's conversations of what to do regarding situations and cases like this that are kind of not those rape cases, they're kind of at the very opposite end of the spectrum. Is there a conversation of perhaps introducing different terminology, of having different categories? Just kind of curious what conversations might look like right now.
I don't think we're not talking so much legislation at this point. When the divorce rules came out, there was a strong push to try to get criminal cases in the criminal context, keep them out of Title IX. That didn't work. I think that we're just people in the respondent world. We're just ecstatic that that the Biden rules didn't go into effect, because they really would have stripped out, they gave an option, but basically hearings were gone, cross-examination was gone, single adjudicator was back. So almost all the due process protections that were put in place by the divorce rules, and I am apolitical, so I'm not pointing the finger at anybody, but those were essentially gave the universities the right to strip them out, and they were very excited about doing it. So we are just feel really blessed that those due process rules are still there, because without a hearing, without cross-examination, you got nothing. If you don't have that procedural due protection, generally speaking, even in their new rules, we win cases in the hearings if it goes that far, because we still don't have investigators who are really pulling out all of the facts that show the student is innocent, at least in general.
You mentioned about hearings. We did request hearings, okay? And I have character witness and recommendation letters, and they list. Hearing was canceled because they didn't have anybody to come and accuse Marcus. So even after that, with no hearing that they canceled, my son was found for sanction. And that's something that I never understood.
I worked on a case similar like that recently with a resident medical student, already as a doctor, as a resident, and he did not have a hearing either at an Ivy League school. And there's currently a lawsuit because first, it was not a sexual assault as we deem as a rape or anything like that. Very similar to your son, actually, Aurora. There was more of a grazed touch and verbal flirtation, and the individual ended up being terminated as a resident and no hearing.
Yeah, I
And
mean,
so,
they should have to hold a hearing even if the complainant decides not to show up. I mean, I've had
Yeah,
multiple hearings where the complainant doesn't show up. I don't think that
yeah, I
I
don't.
don't think that absolves the school of its obligation to hold a hearing.
it does not,
However,
does
if you're
not.
having a proceeding that the allegations happened off campus, that's where we're having a lot of, so you lose the Title IX protections if it's an off campus. So you're seeing a lot of that where maybe this happened off campus, therefore we don't have to, the Title IX rules don't apply, and therefore we don't have to give you a hearing.
Hmm.
So it can be, there's a lot of reasons that it can happen. In situations like that, you have to be extremely proactive in writing all the questions you want, making sure that they do things to establish the record if you don't have a hearing. But prior to the DeVos rules, nobody got it. Almost nobody got a hearing. There was no hearing, there was no cross-examination, and it was the Wild Wild West. So
Right. Yeah, I would always call it that too. It's funny.
Yeah.
I think nowadays I think there's still some similarities to the Wild Wild West from before. It's not as bad, but it still exists,
yeah.
unfortunately. Where campuses are making their own rules and they do classify things as meeting the threshold of Title IX and or not, and then kind of deciding what to do with it. Unfortunately, sometimes not always in the best interest of the respondent, especially. And so I think for today, I just have one final question to ask. What kind of advice would you, Eric, and Sam have for administrations as they are looking to do the right things and maybe start kind of reviewing their own policies to improve things for due process?
Well,
I guess,
I'll
oh,
be,
you go
go
first.
ahead,
You go first.
Sam.
Nope, you go first. You go first.
I'll be try quick because do the right thing. I just had a case in North Carolina where my client was found not responsible for a violent sexual assault, but responsible for giving an STD to this student. Okay, and the school, it was one of the most biased adjudicators I've seen since probably 2019, and we did an appeal, and the school reversed, and they identified bias as the basis, and I was just thoroughly just rejoicing because when you apply due process correctly, you can reach the result. Just do what you say. Be unbiased and be unbiased and fair. And don't be afraid to correct a mistake when a mistake is made because it'll avoid litigation in the long run. If you do the right thing, you won't have people like Sam and I filing lawsuits against you. So that's my advice.
Yeah, and mine was it's related, but I think I was going to make a slightly more specific point, which is that so many schools, and you hinted at this, Eric, have two different policies for conduct that occurs under Title IX or not under Title IX. And so if it's in a campus apartment, you get a hearing and you get to see all of the evidence and all of these things. And if it's off campus, you're out of luck. You don't get a hearing at all. And I think it falls under the category of do the right thing because do the right thing is to let people see the evidence against them, let them confront their accuser. But so often I mean, this is what we saw after the DeVos regulations, right? Eric was like, oh, schools will adopt the regulations. They will give the due process that they have to give under those Title IX regulations, but not in a single other situation. And to me, that's knowingly doing the wrong thing. But I think, I want to see schools, and to their credit, many schools do offer hearings in non-Title IX cases. I would like to see all schools offer hearings in non-Title IX cases because whether I'm representing a complainant or a respondent, I want to see all the evidence. I want to be able to ask questions of the other party. It's what's fair.
That's right. That's what's due process, right? Aurora, would you like to say any final words as we're about to close?
Um, just I'm grateful for Faith and the help that provide for all the family out there. You never know. You wake up one morning and you find a situation that you have no idea, not even that can be possible. And having their support and the service that they can provide and find a great family that is out there, it's absolutely fantastic. So that's what I say. And again, I would love to wake up tomorrow morning and say that it was just a nightmare, and then everything is gone, and my son is happy as he was. That's all.
Well, thank you. Thank you for your words. And again, I'm sorry for what you and your son have gone through. I know many respondents have gone through that. So thank you for being here to represent them. Sam and Eric, thank you for joining us today.
Thank
And
you.
I'd love to have you both back again. I'm sure we can have a lot more conversations about this topic and many more. But for now, we will close our podcast. So everyone out there, thank you for joining us today. Make sure you subscribe and follow us, and please leave a comment. If you need any support from FACE, please reach out to them. We will have the link in our description. And for now, we'll see you next time. Thank you.